Okay. Is everybody glad the election is over? So
Your mic is on.
tonight we have Trevor Potter, an old friend of mine, and Paul Smith, a new friend of mine. And we're delighted to have them here. And after I set the table, Bruce will give them an introduction that they richly deserve. Something is terribly wrong in the United States. The Republican Party tells us it's the Democratic Party. And the Democratic Party tells us it's the Republican Party. Trump tells us it's Joe Biden and Kamala Harris. And Joe Biden and Kamala Harris tell us it's Donald Trump. Every election cycle, we are told that we face an existential crisis if the other side wins. We're suffocated with victim narratives and identity politics. The mission of the Committee for the Republic is to offer you an alternative vision. We talk about the things that Democrats and Republicans don't talk about. The committee goes where the silence is loudest, and the silence is where the real power is. Now, what is America's biggest problem? It's staring you right in the face. It's our constitutional crisis. Over decades, we've generated an epidemic of constitutional illiteracy. We have failed to protect the greatest invention in history, separation of powers. We have normalized a presidency that is indistinguishable from a dictatorship. We have hollowed out the greatest legislature the world has ever seen. We have politicized our courts. Empire is the air that we breathe. In this election, like dozens before it, we have reaped what we have sown. It is the duty of every citizen to master the Constitution and hold our elected officials accountable. Constitutional literacy is our sacred duty. It is the price of our liberty and the inspiration for our faith in our beloved republic. By refusing to pay this price, we have turned our back on the greatest experiment in self-government the world has ever known. Make no mistake, we have no one to blame but ourselves. The notion that the United States is a democracy is misplaced as the geocentric theory of the universe. John Adams said it best, quote, "There was never a democracy yet that did not commit suicide," close quote. James Madison in the Federalist Papers said that if every Athenian were Socrates, the collection of all of them would still be a mob. Jefferson explained, and I quote, "In questions of power, let no more be heard of confidence in man, but bind him from mischief by the chains of the Constitution," close quote. To end our constitutional crisis, we need to rein in the role of the presidency and make Congress and the courts great again. We must have courage to win our Constitution back. We must stop indulging in domestic and foreign fantasies. We need constitutional clarity rather than confusion. We can no longer pretend to have the answers for the world when we don't have the answers for ourselves. We must reject a Wilsonian world and restore and embrace again a Madisonian America. We must make America great again by making the Constitution great again. Okay, Bruce, it's all yours.
You're here.
I was informed I need to speak extra loud.
Yeah.
Let me give you some kind of image of what a Madisonian world would look like. It's 1810, he's occupying the White House. The Senate passes a bill delegating war power to the president to fight the British and French navies who are plundering our maritime commerce. He says, no, you can't do that. I draft the Constitution. Only Congress can declare war. You cannot give that awesome power to one man. Can you imagine that? That's okay. Well, let me take you back more than 50 years. It's a day that I remember very well. I was at the Justice Department. Called October 20th, 1970, Saturday Night Massacre. Remember, Elliot Richardson gone to the White House and he refused President Nixon demand that he fire Special Prosecutor Archibald Cox, whose charter, among other things, was to investigate crimes committed by an incumbent president. Archibald Cox was not a constitutional. He served as Solicitor General of the United States. He had taught me at Archibald as well, but I'm not sure that's a credit. Then, after Richardson's refusal, comes a call from the White House to the department. Alexander Haig, the William Ruckelshaus House, Attorney General. And he shouts, "Your commander-in-chief has given you an order to fire Mr. Cox." Sounds like language emanating from a country which we dare not enter. And Mr. Ruckelshaus said, "No, I don't follow illegal laws. I'll resign." The ensuing battles, this was the beginning of the end of Nixon's presidency. We all know the Supreme Court unanimously ruled he had to turn over the White House tapes, read articles of impeachment, he resigned. Now, I remember during that period, I was serving in the Office of Legal Counsel as a special assistant to the Assistant Attorney General. And we had been approached by the White House, "Hey, come over and defend President Nixon," right? None of us went. We said, we don't strike Faustian bargains. And who was our inspiration? A relative, an ancestor of John Henry. His name was Patrick Henry, right? Richmond Church, 1775. These were the words that inspired us. "Why stand we here idle? Is life so dear and peace so sweet as to be purchased at the price of chains and slavery? I know not what course lies may take. But as for me, I'll give me liberty or give me death." So for that inspiration, we did stand up. The constitutional line held. President Nixon resigned under a cloud on August 9th, 1974. Perhaps the high water of the United States. Most powerful man in the world, driven from office because he couldn't say, "I'm like the king, I can do no wrong." Now, it's unfortunate that in the ensuing 50 years, we have forgotten. Is it not working? In the ensuing 50 years, we have forgotten the lesson of Watergate and William Ruckelshaus and Patrick Henry. Constitutional violations of the White House multiplied, but they didn't begin there. They went back a long ways, and I've posted something on the website showing all the violations beginning with President James K. Polk in 1845 deciding because he couldn't get the Senate to ratify a treaty to annex Texas, he would have a legislative statute that didn't require a 2/3 majority, and then he lied about the Mexican-American War to dupe Congress by saying an American soldier had been killed by a Mexican soldier on American soil, and it goes on and on. But we now have normalized impeachable offenses on both sides. I've been involved in them with regard to Clinton's illegal war. He goes to Congress and asks, "I want declaration of war to attack Serbia." They vote it down. He says, "Well, I'll go anyway, won't call it war." We have Bush and his imaginary weapons of mass destruction. We have the terrorist surveillance program, no warrants, Obama, Libya, I don't need congressional power, on and on and on. Written so many letters, especially when Joe Biden first came into office. We wrote a letter to him saying, "Joe, you remember in 2007, you're on Chris Matthews' show. You're running for presidential nomination for the Democrats. And you shouted at Chris, 'If George W. Bush, the president attacks Iran. I'm going to lead the charge to impeach him. I know Constitution. I was chair of the Foreign Relations Committee, chair of the Senate Judiciary Committee. Said you need to get out of all these wars that we're involved in, still today, as belligerents or co-belligerents. Co-belligerency is a word that people kind of forget. It means systematic to a belligerent, which makes your subject invulnerable to attack. Ignored the whole thing, continues to go on and on as we are now. As we speak today, we have 100 soldiers in Israel, prepared to use the THAAD missiles to help an invasion of Iran. He's providing military assistance, intelligence equipment, everything making us aiding and abetting what Israel is doing without a declaration of war by Congress in Gaza, in the West Bank, in Lebanon, and now in Iran. No pushback, nothing. The best we can get from Congress is occasionally there'll be a handful of members will write a letter to the president saying, hey, you know, there's a constitution. We really would like you to obey it. We won't do anything. We're not going to cut off appropriations. We're not going to file impeachment resolutions, but please do it. And of course, they're laughed at and nothing ever happens. So why do they do this? In some sense, it's what John said. It's because they get no pushback at election time. They get reelected year after year, despite constitutional illiteracy, including not even knowing that we have 3 branches of the federal government. I mean, it's that bad. Not knowing that there are 14 structural provisions in the Constitution that work against the ravages of democracy. 14. They don't even read the document. So it is us. It is the voters who have to take the Constitution back, as Grover Cleveland said. In his first inaugural, he said he takes the oath to support the Constitution, but every American citizen takes that same oath in their own private capacity to support and defend the Constitution and to make sure their elected officials and appointed officials are faithful to their oaths of office. And if it's not done, they aren't going to do it. I've been in Washington many, many years. Most all congressmen, and I hate to say it, are sociopaths. They crave being the center of attention. They don't want to do any work. They love power, standing up and whatever. Unless they fear their jobs are at stake, they're not going to do anything. And we're the only one can put their jobs at risk. We are the only ones at the ballot box insisting unless you take the power back and you decide on war, we're not sending you back. Now, that doesn't mean any change is going to come overnight. It's been a long time before Americans had the courage, or we saw the William Ruckelshaus telling the president, you gave me an order, I'm not complying. So that's the task we have. The task is we make sure that after constitutional illiteracy, the deluge doesn't come because we cure the problem, right? Now, I don't want to suggest that success is likely. It may be that we've already gone too far, as the Roman Empire did when the Senate began passing bills deifying the emperor. So he didn't have to wait after he died to get to heaven. He was a god before that. But there's one thing that we cannot afford to do if we're not to be ingrates to the founders. They suffered at Valley Forge. They risked a lot more than we did, including their lives by signing the Declaration. And that's to fail to try. Now, I am pleased that we have Trevor and Paul here tonight because they are our hope. They are the ones with the stature, the moral and philosophical convictions. They illustrate the kind of citizen wisdom and strength that can return the Constitution. I call them the Babe Ruth and Lou Gehrig of constitutional election law, right? You can't beat that. And with that introduction, I turn it over to you and we have some questions. Do we need to give these gentlemen the mic?
Yeah, so it's been a bit of a technical issue, but you just pass back.
So it's great to be here, everyone. I see a number of familiar faces in the crowd. I've enjoyed coming to these events before. Let me briefly explain that Paul's the law professor of the two of us. I don't even play one on TV. We are both at Campaign Legal Center, a Washington, D.C. based but national nonprofit. We are nonpartisan, so our comments tonight reflect the issues we're going to be talking about, whether it's a Democratic or a Republican president. And we have attempted to defend the rule of law and the Constitution, regardless of party, over the 22 years that CLC has existed. We generally focus on areas of the freedom to vote, redistricting, anti-gerrymandering, government ethics, money in politics, and for the last couple of years have been very focused on ensuring that we had a free and fair, legitimate election, that everyone who should vote could vote, would vote, that the votes would be counted correctly, and the results known. That has all happened this year quicker than I think groups like ours expected because of the margins in the various states. And so now what we are focusing on, and we'll talk about tonight, are some of the issues that Bruce and John have outlined in terms of executive branch power. It doesn't matter that it will be a Republican president, as they've noted. There are Democratic presidents that have done things as well that appear beyond constitutional order. But we'd like to look ahead a bit at some of the issues that we think we're going to be facing in the next couple of years. And this is not because we have a crystal ball and we've been divining them. It is because we are being faced with some of them right now by the actions of the president-elect.
Great. So, Paul, you've argued what, 21 cases before the Supreme Court? Not many people have done that. So let's talk about the Supreme Court, and we'll, my friend Bob Randolph and we're always talking about the Supreme Court. But let's go. We had Judge Luddick, and we talked about we had a Colorado decision, and then we had the immunity decision. You want to start with one of those?
First of all, let me say how glad I am to be here. And also, I'm always happy to talk about the immunity decision, which I have to say, I think is one of the worst and really the most surprising decisions that the court has issued in our lifetimes. It really is quite a remarkable thing. I'm inclined to be a little more charitable about the Colorado case, which, shorthand aside, is the case where they said that they made it almost impossible to enforce the provision in the 14th Amendment that says if you engage in insurrection against the country after swearing allegiance to the Constitution, you can't run the second time. That was last spring. And they had a plain language problem in that case, but it was also kind of late in the day that he was already effectively the Republican nominee, so they had a political problem. But this immunity decision, which basically says as long as the president is engaging in official conduct, however illegal and beyond his powers, he almost certainly will have immunity from criminal prosecution after he leaves office, was so surprising to me. I was inclined to think they were taking their time with it to kind of get past the election. But then when they came out with a thing that said that, the thing that's remarkable about it is these are the justices, the conservative wing of the court, who talk about originalism and textualism and faith to the original Constitution. The dead Constitution never changes. And they didn't have any legal basis offered for this at all. And even more surprising, is completely without any common sense. The President of the United States is the most powerful person in the world. He has the most powerful military he commands. He has the entire federal bureaucracy under him, and we're going to turn all this power over to him. And no matter how abusive of it he is, because his orders to these people are official acts, he's not going to be subject to any criminal prosecution later on. It's a very surprising decision, and I think it is unfortunate because it leaves us with precious few guardrails to deal with a president bent on maximizing presidential power, and in a time when, as you guys already believe and know, the president's already too powerful.
As we speak, there's a prime minister in Israel, Benjamin Netanyahu. There's wartime, and the court said you have to show up in your criminal trial. He's in office, okay? So if Benjamin Netanyahu, in wartime, which he claims is an existential threat, can be forced to testify and the Israeli government doesn't collapse, I think the argument that we couldn't do the same in the United States with prosecuting an incumbent president.
I think the difference is, and I'm sure this won't convince you, Bruce, because you've been thinking hard about this for 50 years and have very firm opinions, but the way the executive branch is organized, everybody in the branch works for the president, including every single person at the Justice Department. And so for them to prosecute him is almost a contradiction in terms. All he has to do is say, I command you not to prosecute me, and that's perfectly within his power as president of the United States. It may be lawless in some sense, but and because the entire executive branch is all within one man, this really is the way that James Madison set it up. To have that person subject to criminal prosecution while he's trying to exercise all these powers, particularly in the complexity of the job as it now exists, I think actually shows that there was some wisdom in the idea that the president shouldn't be prosecuted till he's out of office. And the impeachment clause says impeach him first and then prosecute him. As a practical matter, I'm not sure. I think that the worst thing that ever happened was the OLC opinion in 1974 that said you can't indict the president while he's your boss. That's essentially what they said.
A couple thoughts on this, because I think I agree with Paul. I think it's a extraordinarily wrong-headed decision and a shocking one. The immunity case. I heard Judge Ludick the other night, who many of you have heard here, and he made a point I hadn't thought of, which was, he said, when the Supreme Court was hearing the arguments in this, you had the Trump lawyers arguing for absolute immunity, and then you had the Justice Department arguing for immunity, but of a limited type. And the reason for that is because the Justice Department traditionally has fought to defend the prerogatives of the president and the executive branch. And so what Ludick pointed out is there was nobody there saying, wait a minute, there's nothing in the Constitution about immunity at all. This ought to be an open and shut, crystal clear case. The founders knew how to write immunity because they gave it to Congress in the speech and debate clause. They didn't give anything to the president. So Ludick's point was the Supreme Court started with an argument that was already off base and unconstitutional because it wasn't focusing on the text. It was focusing on where you're going to balance and draw the line between some immunity and a lot more immunity. So that's one thought. The next is that I think in Paul's point about how the court lacked common sense on this, what they have set up is a situation where the president can give illegal orders knowing there are no consequences. Yes, the law says I can't go in and order IRS audits, but if I do that in violation of the law, I'm not going to get into trouble. There are a whole series of things where the law would be clear, and yet the president under this will face no consequences for giving illegal orders. The problem is it is not reciprocal. Everybody else in government can be prosecuted. And so the natural effect of this is you are putting people in the executive branch in an awful position where they're going to receive an order from the commander-in-chief, and if they don't follow it, they can be fired. And if they do follow it, they are subject to criminal prosecution. In the case of IRS audits, I was reminded today, the law is very specific. Not only is it a criminal violation for someone in the White House to request action against a specific taxpayer, it is a criminal violation for any IRS employee to do so. So you're going to have this situation where one person is empowered to give illegal orders and everyone else, whether it's the military or elsewhere in the executive branch is going to be vulnerable, whatever they do. I was asked earlier today whether Paul and I were going to be singing from the same song sheet or were we going to have some disagreements. And actually, this is perhaps the only one. I'm not sure it's a disagreement, but I'm going to pass on a thought on this case because on the face of it, it is such a unbelievably horrible decision and so so contrary to the language of the Constitution that and ahistorical that you look at it and say, how could they possibly have done this? Now, Washington is full of people who know Supreme Court justices and talk to them off the bench. And the Washington rumor mill that is favorable to the court on this is that they thought they were doing the best thing for the country. And the reason is, and again, I'm only repeating the support that is being generated for this decision by friends of the justices, of the majority. But the argument is they thought they were helping avoid a vicious cycle where Trump would be tried for criminal offenses if he didn't win a election, and where if Trump did win election, he would go ahead and charge Biden with criminal offenses, and that the next round would be the next Democrat would then go after the Trump people again. And so the court was saying, we don't want this vicious cycle that we see in tin pot dictatorships where everyone in office then locks up their predecessor. And the way to save not only Trump, but also Biden is to say there's immunity. So if Trump wins, he can't go ahead and prosecute Biden. That is the argument given by the defenders of it. But as I say, I think it has bought a passel of trouble and is ahistorical, and we are really going to regret it.
Well, those are wonderful remarks. I would note that, at least with regard to Trump, virtually all of his accusers were Republicans, many of them that he appointed. Perhaps most importantly, Vice President Mike Pence, who testified and stated repeatedly on the morning of January 6th, Mr. Trump approached him and demanded, you need to choose between me and the Constitution of the United States and counting electoral votes. So it's kind of hard to argue that it's a political witch hunt when the accusers of the defendant are the people he appointed. But putting that aside, I think that you came across a wonderful point about following orders defense. Now, I've read 18,000 pages of the International Military Tribunal at Nuremberg. And what you've argued is what confronts or might confront federal employees, the same kind of issue that William Ruckelshaus confronted on October 20th, 1973, following orders. And virtually all the defendants at Nuremberg said Hitler told he had everything. All the power was in der Führer. What do you expect us to do? Indeed, they said with credibility, we defied his order, we'd be at a concentration camp. And the following orders defense was not successful. That is, the conclusion was that the orders were so far beyond the pale that they had a duty to flout the orders, like William Ruckelshaus did. William Ruckelshaus did not pay a price. He fared far better than the commander-in-chief who gave the order. Now, I know it's a hard confrontation to make, but that's what is necessary, in my view, to preserve the republic. You have to have people who say, I will disobey a clearly illegal order, and I'll appeal to we the people. That is to us. He said, what's to check the president? Us. We're the guardrails. Sovereignty lies in we the people of the United States. And that, in my judgment, is what the framers understood would be the final check. A last observation relates to the idea of unitary executive, and it's some odd to have the Justice Department being prosecuted the president since they're part of the executive branch. It sounds like one branch prosecuting itself. But that is exactly why Archibald Cox was given a special charter. He couldn't be dismissed. There it is, the Justice Department with the president's concerns, placed restraints on its ability to simply follow orders. Without extraordinary improprieties, you couldn't fire Archibald Cox. And indeed, that's what Judge Gerhard Gesell held in a case called Nader versus Bork. So there are ways to fix the kind of oddity of, hey, how can you have the Justice Department be prosecuting the president when you work for the president? Because you have a special prosecutor arrangement, and you know that the Constitution avoids conflicts of interest. They wanted checks and balances. Anything that advances checks and balances is presumptively constitutional. And that's what special prosecutors are about. They do not work for the president. So that's just my observation. But I'm not saying that this is self-evident to everyone.
To remind everyone here, there was a special prosecutor statute, and it was post Watergate that all of that was put into law. And you had the Clinton Whitewater investigations and a range of other investigations, and Congress decided not to reauthorize that statute because it was seen by, I think, many, that the problem with the special prosecutor is that they didn't report to anyone and they had no checks on their power. So we have a wonderful system with checks and balances and so forth, and we put somebody in it who had no checks and balances. And unfortunately, absolute power appeared to corrupt absolutely. And so maybe rightly or wrongly, but the wisdom was this creation is excessive and doesn't do its job, even though, as Bruce points out, the whole point of it was to insulate it from orders from the executive branch. A couple of years ago, there were all these wonderful meetings in Washington in self-congratulations on the 40th anniversary of the Watergate scandal. And I went to a number of panels where people who had been active in the House impeachment proceedings and in the Justice Department investigation and in the courts talked about how it had all unfolded and how there had been, relatively speaking, bipartisan support for an investigation, bipartisan hearings. You know, what did the president know and when did he know it was said by a Republican? And I recall thinking back in 2014 now, I wonder if it would unfold that way today, because the city is so much more polarized on a partisan basis. And so you look ahead to what we saw in Congress under the last Trump term in the impeachment proceedings, and I think it's clear it would not, that there isn't support anymore on a bipartisan basis for holding the executive branch accountable. There is support for your party's president, whichever one that is, and a resistance to investigations by Congress if it's affecting your party. And I do think that's now 50 years post-Watergate, a really signal change is that the nature of how Congress views itself and whether it thinks it is a party structure or a separate branch of government has simply changed. The quotes in the papers recently from members saying, he's my party's leader, not my president, my party's leader. And when he says jump, our question is how high, is, I think, indicative of a real change in the way members of Congress see themselves. And so for the analysis of what's happened with the separation of powers and congressional power, you have to start with the role of the parties and almost the way people in Congress view themselves as parliamentary representatives of a party rather than representatives of their state, their constituents, and a different branch.
That team phenomenon by which people are much less interested in following the law or their duties and more interested in being for their team, right or wrong, I think you can extend it to the Supreme Court. And there are decisions after decisions where it looks to me that the conservative majority is willing to do things that have very little basis in the Constitution. Maybe you could make the point about the liberal minority too. I'm not sure if it's equally true of both teams. It may very well be, but you know, you look back over the last 10 or 15 years, we had this decision where 4 of the conservatives almost threw out the Affordable Care Act under a constitutional theory about the Commerce Clause, which was frankly really ludicrous. And they were doing it because of political opposition to the other team, and that set things off in a way that we continue to see. And I think you have to view the immunity case in that light. And the court gets very muscular when the person on the other party is in. But we're not going to see, I'm afraid, the kinds of checks and balances we need for the next 4 years. And that's something that's very worrisome, because we do have a president who likes to garner power, whatever else you may or may not admire about him. He is not a person who believes in shared power, and there needs to be somebody pushing back.
The immunity, the speech and debate clause, really pretty important. I remember when I got out of college, the only job I wanted was to work for Senator Fulbright, because he held the hearings on the Vietnam War. And then you remember, Bruce, we gave the Defender of Liberty Award to Daniel Ellsberg. Yeah, Dan Ellsberg was forced to go to the New York Times, to the press, because Senator Fulbright wouldn't use the speech and debate clause. Senator McGovern refused to use the speech and debate clause. Who were the Mathias and Paul McCloskey in the House? Yeah, so it was 5. There were not three Judases, but 5. So they forced Dan to go to the press, and so I really, I lost a lot of respect for Fulbright when I learned that, because I didn't know that until 2 years ago. But yeah, so when we say Congress has all the power, they have all the power. This hat says "Make Congress Great Again." People realize, we say there are 17 enumerated powers plus the necessary budget clause. So they got all the power. I don't think there's been any constitution in the history of the world that's given more power to a legislature, and I don't think there was any Congress in history that was more powerful than ours in the 19th century. So the idea that basically we would have an imperial presidency and be here at this point is just shocking. So the immunity thing is real. That's a great point about that Congress has that immunity, right? Because if anyone at the Constitutional Convention had said that we're going to make given the impeachment power, right, making Congress immune, and we didn't give the impeachment power to the president, we gave it to Congress, right? If anybody at the Constitutional Convention has said that we were going to make the chief executive immune from civil and criminal prosecution, do you not think they would have been run out of the Constitutional Convention? Huh? They would have been run out, right? So,
yeah, in fact, Alexander Hamilton proposed lifetime presidency, and he got run out. And that was a lot less than immunity, right? So we know what, they had a dress rehearsal on that score. But I want to mention your wonderful points. Where are the guardrails? The guardrails are us. There are no more political guardrails. We can't rely on Congress. We can't rely upon the courts, as you say. It's us or nobody. Remember, Adolf Hitler was voted by the popular vote. In Germany, they didn't charge that it was fraudulent. And I know it's a hard task, but the price of liberty is eternal vigilance. That means every day. And with regard to the independent counsel statute, just add a footnote. The day afterwards, the Justice Department promulgated regulations, the same ones that were used by Archibald Cox. So it's true that Congress eliminated the independent counsel, but they endorsed or acquiesced in the creation of Archibald Cox 2.0. So that's where we are. You're correct that there is a problem with independent counsels being accountable to nobody. But there's one thing that differentiates independent counsels from the president. They don't have armed forces that can destroy the world 50 times over. They don't have a monopoly of violence and the money to fit, right? So they can be abusive, but the abuses are minuscule compared to a limitless executive.
We've got the appointments power, right? The advice and consent. And so tell us about, we're told that we're going to have a very aggressive use of the recess power. What's the history of the recess power? Where is the power to appoint in terms of making Congress great again? What does that look like?
Well, we're seeing a real effort to exert power over Congress even more by the president-elect, and the recess appointments piece of it is an important piece of it. Let me tell you, the concept of a recess appointment existed a lot in the 19th century when the Senate would be out of Washington for 8 or 9 months at a time. There was so much time when the president was sitting here in the White House and there was no functional Congress because there wasn't any reason for them to be here, and they lived at home. It was a very different world, and there were no airplanes. And so they needed a way to staff the executive branch, or so it was thought by the framers. And the recess appointment concept has largely become irrelevant in the modern age. But this is literally the first time I've ever heard of anybody suggesting that the president and maybe friendly people in Congress should work together to create a gap have the Congress go out of session, have the Senate go out of session for 2 weeks or more, and therefore have the president put his entire cabinet in without any review at all of their qualifications or anything else. And that is the threat that is being held over the Senate by Mr. Trump's people, pointing to language in the Constitution which seems to say if the houses of Congress disagree about whether to adjourn, the president can adjourn them for as long as he sees fit. Now, there are ways maybe to interpret that so it doesn't apply. It's never, ever, ever been done. No president has ever adjourned the Congress, let alone adjourned the Congress and then made recess appointments, having deliberately created the adjournment. But the result of that, if it happens, is that you have people being put in who haven't had their FBI background checks, haven't had any hearings, haven't had any witness testimony against them. All of the checks and balances which are intended by Congress, by the Senate, to keep the executive branch from being populated by very seriously flawed people. But that is the threat that Mr. Trump is using. I do think he'd probably prefer if the Senate, seeing the threat, would just vote for people. And I wouldn't be at all surprised to see he's going to get everybody through because people are kind of afraid right now to defy him in the Republican side of the aisle. There's a lot of concern about violence. We saw Mr. Romney's book about how many of his colleagues are afraid to defy Trump because of the mobs that'll show up at their door and stuff. But the second plan is to use this deliberately created adjournment so they can use the recess appointments clause.
A couple further notes on the recess clause. As Paul noted, it existed for a different purpose, which was when Congress wasn't around. So fine. We get to the modern world where they're here or they can come back on a plane in a day. I looked at some of the numbers. Under Clinton, there were 287 recess appointments, meaning the recess was Congress left for the weekend. Congress tried to counteract that by staying in session, what they called pro forma session, where they would, every couple of days, somebody would go into the chamber and bang on the gavel and bring them into session and out of session and leave, as a way of saying, no, we haven't permanently left town, so the president doesn't have the authority to make a recess appointment. President Obama challenged that because he had nominees he couldn't get through the Senate. And they were either delaying them, not holding hearings, etc., in a situation where the Republicans had the Senate majority and they didn't want to confirm his people. So he said, I have the constitutional power to make recess appointments. They're not actually here. I can do it. There's a Supreme Court case where all the conservatives on the court, led by Scalia, said no. That is not what the Constitution says. That isn't the point of it. The Senate has a core responsibility and right to advise and consent. And as a result, the court created this somewhat artificial deadline and said, as long as Congress is not gone for more than 10 days, there is no recess appointment at all. Another thing that's not in the Constitution, but they said 10 days or more, then you can do a recess appointment. So Congress has ever since, that was 2014, ever since they have continued the pattern of having someone gavel in the Senate every couple of days. And there have been, with that going on, there aren't recess appointments. So in the first Trump administration, what we saw were these acting appointments where somebody who had been confirmed by the Senate to another position could be placed in as acting cabinet secretary or acting deputy secretary because he couldn't recess. So what is happening now, as Paul has said, is that we're ending up in a situation where the president is saying to the Senate, I want you to give up your power to advise and consent. I want you to, in fact, recess for more than 10 days so that I can appoint my people. And presumably this is going to play out in a world where the Senate is not confirming people. If they do, as Paul says, then there's not a problem for the administration. But this, to me, simply fundamentally changes a key piece of the constitutional separation of powers and a key limit on the president. If they are able to, in fact, contrary to the Constitution, put people in office whenever they want by getting the Senate to leave town to enable him to do that. It gets more complex in terms of what happens with the chambers disagreeing and what power does the president actually have under his executive authority, and there will be a debate on that and conceivably a Supreme Court case. But I can't think of anything more important going forward over the next couple of years than this question of whether the Senate either is going to walk away from its power to advise and consent, or is going to be, forced and bullied, perhaps unconstitutionally, to give it up. And I think that's a question we're going to wait and see.
Just to give one example of how this can function, John Bolton was nominated by George W. Bush to be U.S. Ambassador to the United Nations. He couldn't get confirmed by the Senate, so they waited, and then he made a recess appointment, and he served out the term. But I do think that there's one check if the court stands up. You'll notice, Trevor, in the NLRB Noel Canning case, the standing was the party that was injured by someone who had been the subject of an improper recess appointment. And so if Trump tries this end run around the confirmation power, it's vulnerable that every decision made by these recess appointees will be upended in the court. And that's a pretty big risk. I don't know whether they would want to take that risk.
Can you play this out? You wanted to talk about the recess power. How would that play out if he did that?
I don't know they care about the risk. And maybe it plays the other way. If every decision the Attorney General makes is suddenly potentially invalid, that might argue the court would be nervous about invalidating the recess appointment. I don't know.
That is who would be suing, but then much depends on eventually what will the court say, and the court has plain language which seems to support Trump. I mean, if you read it literally, even though this has never been done before, the Constitution is not perfect on this subject. It does say if the houses disagree about whether to adjourn, the president could adjourn them for as long as he thinks they should. Well, that's the clause for the earlier part about him calling them into session. It doesn't say it has to be extraordinary for the adjournment piece, and you could try to bring them together and say that none of this applies except when he's called them into session. But I do not have great faith that ultimately the court would say all of this 2 years after the fact. All of these members of the cabinet are not members of the cabinet.
Yeah, the language we're debating, and Paul and I have been disagreeing on this slightly, as to how plausible it is there's a long list of powers the president has in Article 2. He shall give Congress information on the state of the union, recommend measures he judges expedient, and then Bruce's language, he may, comma, on extraordinary occasions, comma, convene both houses or either of them, comma, and in case of disagreement between them, comma, with respect to the time of adjournment, comma, he may adjourn them to such time as he shall think proper. So you hear that long line with all those commas, and the question is, does he have to have convened both houses in order to have the right to decide when they're going to adjourn or for how long? It's a Supreme Court case waiting to happen, and it will happen in a scenario where Congress hypothetically doesn't confirm the Attorney General nominee quickly enough, and then it leaves, but it keeps a pro forma session. He's asked them not to keep a pro forma session. So the first decision point is, do they leave for more than 10 days knowing what will happen? Or do they stick with what they've done for the last 20 years and have a pro forma session? The next point, and then the theory is the conflict between the houses. The House of Representatives has to say, we want a 10-day recess or a 20-day recess, and the Senate has to not give it, which would, under this theory, create a disagreement between the houses on adjournment. So then the president would step in and say, under my powers, they've disagreed, and so I'm going to adjourn them for 20 days. And in those 20 days, I'm going to make the following recess appointments. And somebody, whether it is senators who say, we were in session, he didn't have the right to make those appointments, or whether it's someone aggrieved by the action of one of the appointees, which takes longer to get that, the aggrievement in order to challenge it. Someone will challenge it and say it was illegitimate, and it goes right to the laps of the Supreme Court as to what this very obscure provision of the Constitution, which has never been utilized or interpreted in 240 years, is suddenly going to be front and center.
So let me just pull back a little here and so we all went to law school and you know, most Americans didn't go to law school, but Alex de Tocqueville wrote in the last century that, quote, scarcely any political question arises in the United States that is not resolved sooner or later, ends up as a judicial question that will turn anything, any kind of political, social, you know, we'll put it into a political question. So so when we talk about constitutional literacy, you know, we had a congressman that told us, you know, when we wanted to talk about the Constitution, we try to get him over to the Capitol Hill Club, and he said it was like a wheelbarrow with frogs in it. By the time you wheeled them over there, you know, they'd all jumped out, even though that club is right next to the House. The Democratic club is much further away. No chance they wouldn't have jumped out. But that if you want to talk to him about the Constitution, which is, of course, what we want to talk about, he said it's like reading Shakespeare to cows. And
I'm surprised John knows where the Democratic Club is.
To go back to the Tocqueville Club, even in the 19th century, everything tends to turn into lawsuits in this country, and lawyers bring it up to the Supreme Court. And that is 10 times more true now than it was then, in my estimation. We saw this with the recess appointment thing. That's just an example of how everything ends up at the court. And the court we have now is very willing to take on the most important controversies that exist out there, and as finding ways to bring power to itself. But I'll give you an example. One of the things we do is elections, and we were spending a lot of time worrying about the election aftermath this time and how it might be or might not be different from 4 years ago. And I was looking at the history of when did the Supreme Court suddenly become the place to go after a presidential election to decide who won. which they did in 2000, and they were asked to do in 2020. Um, and the answer is it's in the Constitution that the Congress is supposed to decide who won the presidential election, and it's very explicit. But in the world we now live in, we turn everything, even things that have been devoted to Congress under the Constitution, into litigation, and the court just goes ahead and decides it.
Deal with the members of Congress. Their attitude is, we don't look at the Constitution, we'll let the courts decide. Don't pin us with accountability. They love that, which is why so many of the statutes are so opaque. Give it away. And the only way that can change is us in the room saying, we're not sending you back if you do that. Open and notorious. You don't need to get security clearances to see what's happening there. And we cannot say depend anymore on the institutional separation of powers. We the people remain sovereign, and keep coming back like a broken record, because that is the only way things are going to change. And that's, if you look at the last 50 years, it's all a one-way street towards more and more aggrandizing executive power. Doesn't matter who's in there, doesn't matter who controls Congress. The thrust is, hey, we want to be Caesar, dominate the world. You have to have Caesar, and Congress then becomes an ink blot. Now, I want to make one last observation historically about the point that you're making, speech or debate clause, Trevor. Remember that there was a torture report prepared by the Senate Intelligence Committee, chaired by Dianne Feinstein. It was their handiwork, right? But Senator Feinstein said, well, the executive branch says we can't release it. Well, so that's the executive branch. I remember in the church committee, Ford told Frank Church, you can't release stuff. He said, so what? I'm releasing it. And he did. And the sky didn't fall. So we approached Mark Udall. He was lame duck, right? This was in the lame duck session of Congress. And we said, Mark, you got the speech or debate clause as long as you're in Congress. You go ahead and do what Mike Gravel did. You have an exact parallel. The Supreme Court has granted you immunity from anything you do. And Congress can't do anything to you anyway, because you're going to leave. American people need to know this is torture that was documented. Thousands, hundreds of pages. And he wouldn't do it. He just shrugged his shoulders and says, well, I want to go back to Colorado. So the only way that attitude changes is if we vote these people out of office and demand some vetting. I know it's a hard thing to do, but people have to get involved. And so we go back with what John said. Where's the ultimate blame? Right in this room and everywhere else.
During the pandemic, we had the largest piece of money in the history of the world, transfers of what $3 trillion, no hearings. And McCarthy and McConnell got together with Pelosi and Schumer, and they decided to violate the Constitution in terms of a quorum and in terms of a recorded vote. So if I want to run against you, right, I have to, and I can't run against your record. I can't really run against you, right? And Tom Massey came up here and forced them to have a quorum, and I think they fudged it at a record vote. And Trump said, I'm going to take you out. He got him on the phone with him. So and that's when I supported him. He stood up Trump. So that was pretty shocking. No hearings, $33 trillion transfer of money, no hearings, violate the Constitution. And did you read that in the New York Times or the Washington Post? Shocking. And then the one that we always want to talk about, because we think war is man's biggest problem, and the war power. So I was talking to my friend Richard Vigor the other day, and they were talking about cutting. Musk is going to head this commission to cut the government, and I said, well, we're putting about 25% of the GDP through the federal government. Why don't we start? We're spending about $1.5 trillion fully loaded on military, when fully loaded, and that's a good place to start. You know, no, I don't want to talk about that. So we want to talk about what nobody talks about, which is the war power. And the war power, is it's first degree murder when the government can order the murder of people, and it's legal, and the law is always silent. And so I think was man's biggest problem, and so we've totally failed. I mean, it's we've
We've written presidents time after time. Trump, Biden, Obama, drafted articles of impeachment. You got to go to Congress. If it's a good idea, Congress should vote for it. They do the same Pledge of Allegiance. They sing the same national anthem. They have the same loyalty. If you have a good case, make it out. Nothing. And Congress doesn't care. They won't do anything. But when you actually give it to them, like in 2013, Obama goes to the House and the Senate and says, we need a declaration of war against Syria because of the alleged chemical weapons use. Got nowhere. So Obama said, okay, I'll just do it on my own then. Any impeachment hearings? No. Power of the purse to cut off the money? No. Nothing. So that's where we are at present. But I wanted Trevor and Paul to respond to this related constitutional issue that we can see coming. The power of the purse. You remember years ago, 1975, the Supreme Court said there's no impoundment power. If Congress appropriates the money, you got to spend it. And then you have the Impoundment Control Act that puts some procedural guidelines in. But now we have statements saying it doesn't matter that the Impoundment Control Act is unconstitutional. The president has constitutional authority just to decide not to spend any money. And James Madison was writing in the Federalist Papers that the power of the purse was the clincher that the Congress had over the president, right? And this is where we are. What do you think is going to happen on the power of the purse with this Congress?
Well, there are a couple thoughts on that. First is that you have the vice president-elect who said during the campaign that he was very much in favor and commended to us the historical example of President Andrew Jackson, who, when faced with a Supreme Court decision he disagreed with, said the Chief Justice has made his decision, now let him enforce it. So, you have a view that says we're the executive branch. We don't have to follow court decisions. And as we've been discussing, you now have an executive branch and a president who knows he can't be criminally charged with violating the law, no matter how clear the law might be. So what are we going to do when you have an executive branch that ignores the Supreme Court's decision, the one you cited in 75, and presumably comes right back up to the court? You would expect Congress to step up, but as I've noted, I think one of the problems with Congress at the moment is the political lineup means that the president's own party doesn't want to challenge the president, and that's not new. We've seen that for the last number of administrations. Anything you want to add to that, Paul?
The American people have that same fragmentation, the same tribalism. So that's why I keep going back to the source. Congress is a mirror image of the voting public. Unless the voting public changes, they aren't.
And as we all know, the framers didn't expect us to have political parties. They called them factions and thought they were evil and wrote wonderful treaties about how if you have political parties, they will want their own success rather than the country's success, and they will band together in ways that are inimical to good public policy. So that's one of the places where the framers really were blind. They didn't like what they saw in England with two parties, but I'm curious, and I don't know enough history to know why they thought we could avoid them. I mean, we had them within 8 years of the Constitution.
George Washington. He won unanimous election to the presidency twice. Virtually no dissent. He turned down a crown 3 times. So, being people who don't have clairvoyance to see to the future, figured, wow, we don't have to worry about the factions, even though there were obviously differences between Jefferson and Hamilton in the cabinet. But George Washington still was a unifying factor. I mean, they had to pull him out of Mount Vernon to come and serve even a second term. So that it ended up being a misconception that George Washington would be followed by another George Washington, because there wasn't anybody who ever came close to winning unanimous votes, in the Electoral College. But I think that, in my view, their backup, if you will, is really the principles of the Declaration, that stating that a people have a right and a duty to change their government if it becomes inimical to securing the rights to life, liberty, and the pursuit of happiness. Now, how that comes about, probably not through court decisions, probably a more messier way, but that was, I think, the substitute for, Congress.
I would just make one other point about Congress, and how you guys are of the view that it's always been ceding too much power over the years. I think Congress is way more dysfunctional now than it used to be back in the days of Fulbright and Dirksen and all those guys, and it's because of the way our political culture has evolved to the point now where all the Republicans are way over here, and all the Democrats are way over here, and there's no Charles Percy in the middle, and so the warfare in Congress has gotten crazy. Maybe it does reflect the American people, but we used to have conservative Democrats and liberal Republicans. There was the same spectrum, but now nobody can work together, and so this is a problem which I don't even know how the American people can fix it. But maybe there's a way you can come up with it.
Well, and that does reflect, I think, as Bruce says, the polarization of the American people. There are all these look back charts at how many states used to have two senators of opposite parties. Now I think we're down to 3, and there were a majority of states that did that. How many states had governors of a different party than the legislature? Almost none now. So we are seeing that polarization, I think, throughout the system, and so, as you say, Congress reflects the people. I have a additional point I want to make, as long as I'm looking at this room, and that is that something you may not have heard about, but I would like to flag for you as an example of Congress potentially giving the executive branch truly frightening power. There is a bill currently before the House, so it has the approval of the Democratic leadership, has a lot of Republican support. They tried to put it through last week on the consent calendar. It didn't get 2/3, so it is supposed to come back up this week for a majority vote. The cover for the bill and the first part of the bill is a totally sensible response to an idiotic government decision. The IRS maintains that there is nothing in the tax laws that allows them to treat Americans who are held hostage abroad or captive differently than any other American in terms of the requirements that they file tax returns and that they pay penalties if they don't. And so the IRS has said, Congress needs to fix this. Fine. There is a bill to fix it that says if you're held captive abroad, you don't have to file your income tax returns while you're there. To that has been added so that's very popular. To that has been added another provision that says that the Secretary of the Treasury of the United States shall have the authority to identify any 501c3 organization that the Secretary believes is supporting terrorism without any definition, and send that organization a letter saying that a determination has been made that they are supporting terrorism. They have 30 days to respond. There is no judicial proceeding. There is nothing in the bill about evidence or anything else, no presumptions. After 30 days, the Secretary may revoke their 501c3 status, and as an organization that has been officially found to support terrorism, they lose all access to the U.S. banking system. So any charity in the United States that whoever the new Secretary of the Treasury is chooses to shut down, Congress in this bill would give the Secretary the authority to do that. Now, the background is this came out of statements. So we now have a First Amendment issue. This came out of statements by various organizations supporting the Palestinian cause. And Congress was reacting by saying, well, if they're supporting the Palestinian cause, that may be supporting terrorism. We'll leave it up to the Secretary of the Treasury. But it's not, of course, limited on its face to that. And so if you just hypothetically had a president who wanted to call their enemies terrorists, and could tell the Secretary of the Treasury to go after that terrorist, you could shut down anybody who criticizes the president under this if they are a C3. So won't surprise you to know the ACLU has been ringing the alarm bells and saying this is a problem. I don't anticipate this Congress passes that. I don't know what will happen in the House this week. The Senate has it in committee. I would hope the president wouldn't sign it. But as of January 20, you have a new Congress, a new president, and a pathway here to, again, giving the executive branch enormous authority over the lives of Americans in a way that the founders never would have dreamt.
I think it's even worse than the nightmare you painted, because there's a criminal prohibition upon material assistance to terrorism. Not only will they lose their 501c3 status, they'll be imprisoned for life for providing material assistance to terrorism. No, but material assistance has been interpreted to include even providing legal advice as to how you can achieve peace. Providing your body and your services has been interpreted to fall within the material assistance statute. It covers virtually everything.
Okay, so let's, why don't we open this up? I think Travis Brown, here's a,
Don't be afraid to put your mouth right on it.
I'm unafraid to put my mouth right on it. Travis Brown, an attorney in Washington. I rise partly on a point of order and partly with what I hope is a substantive question. The point of order is to thank you. Thank you, John. Thank you, Bruce, for convening us, for your initiative, for your network, for doing this. This is terribly important, and now more than ever. And so I thank you for doing that. Trevor and Paul, thank you both for being here. Thank you no less for what it is you do in your day jobs. So I take it your day jobs extend into the evening. So that's important, I think, to say. The question I'd have, partly to Bruce and to Trevor and Paul, Bruce, you say the remedy is we the people. And at one point you flattered the audience or described the audience as saying us. I used to think we the people in constitutional and mathematical terms was something of a constant, that is to say, in the algebra of constitutionalism, we the people was meant something. It would be, shorthanded as a K. It was a constant. I'm more inclined now to say, no, it's a variable. I don't know what you mean by we the people. I might know what you mean by us in this room, but more broadly and more metaphorically, I no longer, and with each passing day, I feel more ignorant about what that phrase means, partly as we the people appear more fickle in our ability to be influenced. Why don't I leave it at that and ask perhaps if Bruce, Trevor, and Paul would speak, how do we move beyond the hyperpower of the executive, at this point rubber stamped by the Supreme Court with a sleeping legislature, to, I don't know, get we the people out of our coma? Thank you.
I don't think we the people has changed. We still have a process here, certainly when we come to elections, that those who win the most votes then are elected. And we the people are the ones who determine who will be elected. And also, even after election, they write in, they have their voice heard, the internet, mail. Let me give you two examples. One was at a time of Watergate. Now, Trevor, I think, is probably an apocryphal tale about Andy Jackson and Chief Justice Marshall, but assume the president says, I want to defy the court's decision. There's a Friday. The U.S. Court of Appeals told Mr. Nixon, you got to hand over these White House tapes to the grand jury in D.C. He said initially, I'm not going to do it. He wanted to hand them over to John Stennis. He was a very aging senator who was deaf and blind, and he could listen to the tapes, Over the weekend, millions of telegrams came in from we the people. Said, you do that, we're going to ask for your impeachment. On Monday morning, Mr. President Nixon said, I'm going to comply with the order. That's we the people. Now, I had a second idea. This came also with regard to the request of President Obama for declaration of war against Syria in 2013. This is Thomas Massey told us that. They got all the members, got telegrams, emails, phone calls. Do not vote for war. We're going to vote you out of office if you do that. And he didn't get a single vote. So it's still we the people, as long as we make our voice heard, can still determine how Congress acts, and the president as well. In my judgment, the reason that they're so emboldened, they do these outrageous things, including what Trevor described as this bill. Instead of saying, this is terrible, I'm not waiting, I'm writing in right now and say, if you vote for that bill, I'm never voting for you again. And not by a stamp, a robocall, or anything like that, personal mail. I mean, the members really do pay attention to that. I mean, I had children who served in congressional office. They really pay attention to something that's personal, not sent by organizations, a postcard. No, it's hard to do, but that's where we are. And you talk about, are we the people different than we were a long time ago? At least in the sense of fragmentation, yes. But the whole reason, the whole definition of the United States is we're one when it comes to defending the Constitution of the United States. That's what makes us American. Doesn't matter where we were born or anything else. And if we lose that, then you're right. Then we're no longer a people anymore. And we're going to find the fate is very unpleasant. It'll be like the Roman Empire.
It's a great question. Something that hasn't come up tonight at all is social media, silos of information. I think a big piece of the polarization we have comes from the fact that people get their information from the right or the left, whatever those are. Some of it identifiable in the TV world, but a lot of it through X, through whatever website information silo people are in. And so I think it is harder to cross that barrier when you're talking about we the people speaking to Congress, because it doesn't matter whether this is an action by a Republican or a Democrat, they are more likely to hear partisan voices from the people. Don't do that because that's the other party and we don't want you to do that, or do it because it's our party and you need to support our party. So what is missing from that, I think, increasingly, is the notion that you hear from a community, that you hear from your constituents more broadly, because I think we've lost a lot of the glue that holds community together. We're more atomized, and you have fewer community newspapers, fewer community organizations. There's I'm sure you all know or have heard of Robert Putnam, the professor who wrote that book, Bowling Alone, saying the great problem for democracy is that people are no longer joining community groups. There's a new documentary film out on that called, I think, Join or Die. And what it says is that the way we deal with who we the people are is by talking to each other physically in person, which means not on the internet to somebody you don't know in another state, but to your neighbors. And without those community groups, you don't have that sort of community discussion. I know you have Sunday morning coffee and community discussions. That is increasingly rare. And so I think that Travis's point is the we the people has become so fragmented, and what they're hearing is so particular to one side or the other, that we have lost the power to have a community-wide voice.
The only other point I'd make, Travis, is one of the things that's really worrisome about the state of the country right now is how many people seem to have lost faith in the Constitution and in democracy as a guiding principle of the country. And I say that in part about the people who thought it was more important than Mr. Trump stay in office and so attacked the Capitol. But it's just as true on the other side of the aisle. If you look at young people in college or these days and ask them, what do you care about most? They will say social justice, but they will say not democracy. They think that the government is so ineffectual and so bad at producing what they care about that they would rather see a country governed by somebody who doesn't have to deal with the constraints of all the rules of the Constitution. So this is a really shocking amount of slide into a world where people on both sides are looking for strength and leadership, not constrained by constitutional norms and rules. And it's very, very worrisome.
Paul Smith, I heard you say that Congress is way more dysfunctional than it used to be, and then you cited the missing middle. In my words, you cited Charles Percy. Some might add, I think, Mac Mathias, even Jacob Javits, Clifford Case. Okay. That's the problem. Here's my question, and we just did it here in the district. Question 83, ranked choice voting. It exists in Alaska. It exists in Maine. There are some other states moving in that direction at state level, but not federal, not congressional. My question is, could it be the missing middle? Could come if there's a way to mandate ranked choice voting for Congress.
Campaign Legal Center are strong supporters of a particular form of use of ranked choice voting to try to attack that very problem, and that is the system in Alaska. Did it get repealed yet, or is that it's on the ballot whether they're going to keep it or not? But what this system does is says we're going to have a primary, and it's not the Democratic primary and it's not the Republican primary, because those are where you get extremes. It's a nonpartisan primary, and we're going to take the top 4 people, maybe the top 5 in different forms of this, and they're all going to be on the ballot in November. And they can tell you whatever they want about their party affiliation or not. And then you use ranked choice voting. And what that does is it makes it possible for people who tend to be centrist to win. And so a Lisa Murkowski would not still be in the Senate if it hadn't moved to this system, because and they would never in a million years have elected a native Democrat as a member of Congress in Alaska, centrist person as well. But you can change the arrangements in our democracy. And the nice thing about this particular reform is you don't have to amend the Constitution. You just have to do it at each state level. Unfortunately, a number of ballot measures to try this in other states just lost. And so there needs to be more effective campaigning for this. And there are times when ranked choice voting gets a bad rap because it's complicated. But really, I think is a very important reform.
This is not a reform that either party likes. And in Republican states, their view is, why would we interfere with the process that elects Republicans, and we do it through our primaries? Exactly the same on the Democratic side. This year, the entire Democratic establishment in Nevada opposed a ranked choice reform measure, saying we normally win elections in Nevada, so what's wrong with what we have? The Alaska situation is interesting. It was adopted by citizen initiative, as all of these are, as they were in the district, because legislatures don't do it, because they got there under the party primary system. And it was adopted, 4 years ago now, I think, in Alaska by a very small margin, but adopted. And then they had this election, which was regarded by those of us sort of good government types as proof of how well it worked. They elected a Republican, an independent, and a Democrat to the three top positions. The Republicans hate it in Alaska because they didn't get Sarah Palin into Congress, and they reelected Murkowski, who had been a Republican but ran as an independent. Alaska is a Republican state, so there are more Republicans up there to hate it. And there was a repeal proposition on the ballot this year, and a lot of money spent to repeal it. Every morning I wake up and I refresh my New York Times Alaska page, and every morning the votes to repeal it, the margin shrinks, and the votes to keep it go up. And as of this morning, repealing it is ahead by 1,000 votes with 20,000 still to count. So it's going to be very close. But as Paul said, there were a number of proposals around the country. Some were very close, some not so close, but the only one that passed was the District of Columbia. And this is a problem for independents who are locked out of system. I think that's why it passed in the district. And we need to find a way to have a bigger pool of voters participating in who gets into the general election ballot, because so few people vote in primaries, and so you have a minuscule portion of the electorate selecting the general election candidates. Then you combine that with gerrymandering, and whoever wins the party primary in many places is going to win the general election because the congressional districts have been slanted. So opening this up somehow to other voters earlier in the process, I think, is really important.
I agree with your observations, but I think what's equally alarming is that the greatest, I think, transgression on the Constitution received support from both sides of the aisle. The warfare state, the surveillance state. There's no debate. No centrist, no right, no left. Everybody's in favor of Caesar. Everybody was against Ed Snowden and the idea that actually the Fourth Amendment meant something. There have been no changes on that score. And so I certainly would applaud at least moving a little bit towards the center. But the fundamental defections from our Constitution are supported by right, left, center, or otherwise. Because as you pointed out, Paul, total breakdown in understanding that process is more important than personality. And if you don't understand that, you don't understand why we have a Constitution. I remember there are claims after O.J. Simpson was acquitted Mark Furman and the N-word and the glove. Oh, we need to do away with the jury trial. I said, wait a minute, process we still have to respect. We can't just go with vigilante justice because there was one malfunction. And that's what I feel is very, very alarming.
So this has been a very, we have one, okay, we'll take one more question here.
Thank you for. Okay, thank you for taking my question. And I want to compliment everybody here because the average IQ level is much higher than those of the current and past members of Congress. That's from my observation. Augustus Salgona, family, extended family, been in this town since 1955, seen presidents come and go, et cetera, et cetera. Okay, basically, and the role I played in the 2016 and 2024 campaign, I was a shadow senior foreign policy and social issues advisor, Trump for President campaign. I also headed up community organizer, Catholics for Trump, Filipinos for Trump, and Rockers for Trump. And but anyway, am I the only one here in this room who wasn't surprised by the Trump-Vance victory? Was there anybody else? Anybody else? Oh my gosh. Once again, I'm forever a minority in this town. Model minority. Okay. My question is this. Should Edward Snowden, does Edward Snowden deserve the Presidential Medal of Freedom, given all that has happened, that if he hadn't have done what he did, certain things would never have happened? Now, granted, there is a genocide going on in the Middle East right now, Gaza, Palestine, okay, which the legacy media is certainly ignoring. And there are, of course, other fake news, misinformation that keeps going on. So anyway, that's my basic question, and anything related to it as a comment.
Interest because I represented Lon Snowden, his father, after he was gone from the United States. And Ed Snowden was indicted, and he still is indicted, for revealing government crimes, illegal surveillance against American citizens, in violation of the Foreign Intelligence Surveillance Act. Remember, the Foreign Intelligence Surveillance Act anticipated the fact that we might be at war and the president might need to surveil for a period of time American citizens without warrants. It said there are 14 days you have, and after that window closes, you need to come to Congress to amend the statute if you want warrantless surveillance. Of course, that didn't happen after 9/11. And I advised it's unconstitutional to charge an American citizen with a crime for exposing government wrongdoing and crime. That is Kafkaesque. That doesn't do an injustice to Franz Kafka. After the disclosures of Mr. Snowden, the cases, I was involved in some of them, percolated in the courts. Finally, the U.S. Court of Appeals for the Second Circuit held that what the government was doing was illegal. It was not authorized by the Foreign Intelligence Surveillance Act. Congress, however, they get railroaded by the intelligence community. Well, the sky is falling. We need to amend the statute. And they amended the statute. It should probably be called the Ed Snowden statute. But until that time, the members of Congress were screaming at Ed Snowden, calling him a traitor. He was terrible because he exposed that Congress did no oversight. That was what their embarrassment was. He actually attempted to go to Congress. They turned him aside. It was a little bit like Dan Ellsberg and the Pentagon Papers. So we now have a situation where Ed Snowden is in Russia. I don't think the United States actually wants to bring him back for a trial, because they would have to disclose all the illegalities that the classified information would reveal, which would be necessary in order to prosecute the case. So does Ed Snowden deserve I think there's a Congressional Medal of Freedom, Presidential Medal of Freedom? Yeah, I think he did. He did a magnificent job in trying to protect our Fourth Amendment rights, and now he sits, in Moscow. That shows how low we've fallen. And I must add this footnote. The spark of the American Revolution was a protest against British writs of assistance, violating, in some, the rights of privacy of Americans, where British officials could come and rummage in your home and search for contraband or whatever. And I always like to quote the spirit of the Fourth Amendment, William Pitt the Elder. The poorest man in his cottage may bid defiance to all the forces of the crown. The roof may shake, the wind may blow through it, the storms may enter, the rains may enter, but the King of England cannot enter. All his forces dare not cross the threshold of the ruined tenement. That was the Fourth Amendment then. Now it's shredded to nothing.
So Trevor, it's been great, but why don't you say a few words about your organization and then we'll end.
Thank you all. Thank you for your patience. Thank you for inviting us. I just wanted to say that Paul and I don't do this very often in terms of having a chance to have a conversation like this, but we do spend our days working to defend the rule of law and to protect the Constitution. We expect we will continue to do that over the next years, and feel free, please. I invite you to take a look at our website, Campaign Legal Center. We would appreciate help. We're going to need lots of help for our work over the next couple of years. So we'd be happy to have partners in that goal.
Thank you, Trevor. Let's hear it for Trevor and Paul. Great. Thank you very much. Good. Thank you.